As we have stated in the past, granting judgment at the close of a plaintiff's case is a practice that is not well advanced or well advised from the standpoint of judicial economy. As a leading commentator notes, if the jury is prevented from passing on the issues, an appellate court that disagrees with a verdict directed by the trial justice has no jury verdict to reinstate, wasting the time spent on trial. Unless it appears that the defendant's case will consume an inordinate amount of the trial court's time, the better practice is to submit the case to the jury, which in some instances may obviate defendant's CPLB 4401 motion by returning a defendant's verdict. See Goldberg versus Bar Steel Construction Corp., 37 Appellate Division 2nd, 162, 163. The court properly granted the people's motion made during jury selection to reduce the charges of grand larceny in the second degree and criminal possession of stolen property in the second degree to the lesser included offenses of attempted grand larceny in the second degree and criminal possession of stolen property in the third degree, respectively, even if the court's action could be viewed as an amendment of the indictment pursuant to CPL 200.70, the court did not impermissibly add new charges. Compare People versus Perez, 83 New York 2nd, 269. Because each of the original counts of the indictment necessarily contained the respective reduced charges as lesser included offenses of those counts. Moreover, the court clearly would have been entitled to submit these lesser included offenses to the jury at the end of the trial by instead reducing the charges at the beginning of the trial upon the people's concession that they could not prove the greater charge. The court could not have caused any prejudice to defendant. On the contrary, the prompt reduction tended to minimize any possible prejudice. See People versus Mendez, 63 Appellate Division 2nd, 69-72. In any event, the court's action also constituted the functional equivalent of a reduction of the charges pursuant to CPL 210, made in this case on the people's concession of insufficiency before openings and the taking of any testimony. We have considered and rejected defendants' remaining arguments to the extent that the trial court set aside the verdict as against the weight of the evidence. This was beyond its powers. However, the court properly set aside the verdict based on legal insufficiency, since the people failed to establish defendant's guilt as to every element of the offense charged. The well-known standard of review in determining the legal sufficiency of evidence to support a guilty verdict is whether the evidence viewed in the light most favorable to the people could lead a rational trier of fact to conclude that the elements of the crime had been proven beyond a reasonable doubt. In the instant matter, the people alleged that the defendant, an attorney, conferred or offered or agreed to offer and confer a benefit upon a court clerk in return for the clerk's assistance in expediting matrimonial cases. However, the evidence established only that there was an agreement for the clerk to perform paralegal services for defendant and for defendant to compensate the clerk at the prevailing rate for such paralegal services. The paralegal services which were actually performed involved the preparation of documents in uncontested divorces, a matter in which the clerk had expertise. The expediting of some of defendants' cases was an accommodation that was commonly granted to other attorneys and for which defendant neither paid nor was asked for compensation. The evidence failed to establish an agreement and also failed to prove the disjunctive requirement of an understanding. The people were required to prove an understanding in the mind of the bribe maker that the bribe receiver would effectuate the proscribed corruption of public process and was affected to do so by the actus reus of this particular crime. The mere hope that the public servant would be influenced by the benefit offered or conferred is insufficient. The requisite agreement or understanding cannot be inferred from the evidence. There was no evidence supporting an inference of an agreement or understanding that defendant would continue to provide the clerk with paralegal work in return for assistance in expediting cases. Furthermore, in response to clarifying questions, the clerk specifically testified that he received nothing extra for expediting cases and that there was an agreement to that effect. We have considered the people's remaining arguments and find them unavailing.